Welcome everyone. Thank you for joining us this afternoon. We're going to go ahead and get started with the presentation. If you're watching us live, you know that there is an option to raise your hand if you want me to unmute you so you can ask a question. There's also a Q&A box. You can type a question in and we'd be more than happy to answer it. So with that, I'm going to go ahead and share my screen. We've prepared a short PowerPoint presentation for you. The entire presentation today should be done in under 30 minutes.
As you're doing that, we should probably introduce ourselves. I'm Karen Connolly. This is Amy Lee Hogan-Simonovich, and we're both attorneys at Ridge & Downs.
Okay, so Karen and I concentrate our practice in the area of Illinois workers' compensation litigation. Ridge & Downs as a firm also does other types of injury, personal injury law, as well as FELA work for railroad workers. But what we've invited you here to talk about today specifically is the COVID-19 presumption. The Illinois legislature has prepared an amendment to the Illinois Occupational Disease Act. It has not been signed into law yet by Governor Pritzker, but we expect him to sign this into law shortly. And we want to make sure that everyone is prepared for what this is going to entail. So the first question you might be asking yourselves is, why is it important for a COVID-19 condition to be considered work-related? So I'm going to start by explaining your basic rights under the Workers' Comp and Occupational Disease Acts. The first is the right to payment for your medical treatment. So especially important for those who end up hospitalized as a result of this condition to get those medical bills paid. The second right is payment of weekly benefits while you are off work recovering from COVID-19. And the third is a right to permanent partial disability benefits. And what that means is that you would be entitled to a type of settlement or reward for the residual damage to your body as a result of this condition. I'm sure many of you are aware that the science is still developing on this brand new disease, and we're not entirely sure what the permanent impact is going to be from individuals who contract this disease. And so it's important to make sure that those residual effects are covered. Karen, can you go over some of the basics of proving a work comp case?
Sure. In proving a workers' compensation or occupational disease act claim, whether it's COVID-19 related or otherwise, there's several things that need to be proved. First of all, the person who is bringing the claim needs to prove that they had an accident. In order to prove this, the incident that occurred where the person was injured must arise out of it in the course of their employment, and these refer to the fact that there must be some risk involved in the employment that led to the incident. In causal connection, one also needs to prove causal connection, and what that means is that the accident has to have a relationship with the condition that you are claiming to have, and the condition that requires the need for medical treatment, lost time, and the permanent disability benefits. You also need to prove, if you do lose time from work, that that lost time is related to the accident, and of course you need to prove that the condition had permanency if it does.
So the next slide is a summary of what the legislature has prepared. And this is that if first responders and frontline workers contract COVID-19, there is a rebuttable presumption that the disease is related to their employment. The presumption applies to both the accidental exposure and the causal relationship between the exposure and the employment. That is some strong legalese, and so I'm going to have Karen go ahead and explain what a rebuttable presumption is.
A rebuttable presumption is just an assumption of fact accepted by the court until it is disproved. In this case, the assumption is that the person, if they are a member of certain classifications, If they develop COVID-19, the assumption is that that exposure is related to their employment, and that the employment-related exposure is causally related to the development of the COVID-19. This can, however, be disproved by the employer, and there's several ways that the legislature has set out to disprove that. We will talk about those in a little bit. What's really important to understand about a presumption is that it's not an absolute. It doesn't mean that because you're a member of one of those classifications that the legislature set out and you get COVID-19 that you will automatically be covered by the Occupational Disease Act. What it does mean is that it's much, much easier to prove that you'll be covered under the Occupational Disease Act. It's a very strong presumption, and we think it's going to be very helpful for people who who are exposed and contract COVID-19, but it is not an absolute.
So I'm going to talk about who is covered by this rebuttable presumption provision. And there's two basic categories. The first being those first responders to the COVID-19 pandemic, and that includes police, fire personnel, emergency medical technicians, paramedics, all individuals employed and considered first responders, all healthcare workers, including nursing homes, rehab facilities, and home healthcare workers, as well as correctional officers. So you'll notice that healthcare workers are being included in this first category of first responders. The second category is frontline workers, and this is defined in the executive order by Governor Pritzker from March 20th of 2020. And you may remember that this is a very broad order in terms of the categories of workers that are covered. You've got human services operations, essential infrastructure workers like water, sewer, gas, roads, highways, railroads, internet and video communications, essential government workers, essential businesses, including stores, grocery stores, food and beverage, manufacturing and production, media, gas stations, hardware stores, critical trades, and restaurant workers. There's so many various types of workers included in this order. If you have any questions with regards to whether you fall into those categories, please don't hesitate to reach out to me. There is a restriction applied to this category, and these workers must be required by their employment to encounter members of the general public, or they must be required to work in an employment location of more than 15 employees. There are three main ways that your employer can go about rebutting this presumption with evidence. And the first is that the employee was working at home or on leave from the employment for a period of 14 days immediately prior to the injury and exposure. So you have to ask yourselves, did you go into work within the 14 days prior to you coming down with COVID-19? The second way an employer can rebut this presumption is with evidence that they were engaging in and applying to the fullest extent possible or enforcing to the best of its ability industry-specific workplace sanitation, social distancing, and health and safety practices based on CDC, Illinois Department of Public Health guidelines for at least 14 days prior to the injury and exposure. So what this means is that it's going to be very case specific in terms of when you come down with COVID-19 and what the guidelines are at that time. If you contracted COVID-19 back in March or April, the specific guidelines and what practices were being recommended at that time will be very different than what is currently being recommended now. So it's going to be different kind of for everybody. everybody's unique situation and timing. And the third way an employer can rebut the presumption is with evidence that the employee was exposed to COVID-19 by another source. And what we're talking about here is other activities in the public, such as attending a barbecue or other party, your vacation or travel plans, perhaps evidence that your spouse was symptomatic first, suggesting that maybe they brought it home from their workplace. And this evidence is primarily going to come in two forms. We're going to see evidence of social media posts, Facebook, Instagram, photos of you at an event or party, a backyard party. Also, maybe word of mouth, especially in small towns throughout our state. It's very common for everybody to know everybody's business. And so it would be very easy for an employer to find out what their employees have been up to outside of work hours. Karen?
The legislature has set up several rules about the presumption. The first is the presumption is applicable between March 9th of 2020 and December 31st of 2020. So for those people who meet the criteria that are set out, if you're diagnosed between those timeframes, the presumption can be applicable. The second is the way in which the diagnosis needs to be proved. If you are diagnosed before June 15th of 2020, the diagnosis can either be confirmed by a medical professional or a positive laboratory test or antibody test. After June 15th, 2020, it must be a positive laboratory test or antibody test. It's our understanding that this is because there was not enough testing available early on in March and April. And some people who were exposed and got sick were not able to be diagnosed by testing, but that should be cleared up after June 15th. So it's very important, if you think that you were exposed, if you think that you're positive, go get a test. And this is probably the most important thing that you can remember. If you do not fall into those categories where the presumption is applicable, or your employer is able to rebut that presumption, you still can prove a workers' compensation or occupational disease claim. There is nothing that precludes us from going forward and putting, if we can find the evidence to show that you were exposed at work, we can go forward with a claim. So people who were exposed but don't fall into those categories, and people who have their employers able to rebut the presumption, are still able to go ahead and have a claim if there's sufficient evidence. So please remember that.
So when Karen talks about sufficient evidence, what do we need to prove the case? Now, this is important regardless of whether we're proceeding with the rebuttable presumption or not. The first thing we're going to be looking for to help us out would be evidence of work-related exposures. Now, that is primarily kind of two different things. If you've been notified by your employer, perhaps there's been an inter-office memo notifying you that one of your coworkers has tested positive and you may have been exposed. That's going to be one of the most common things that we'd be looking for. Obviously, that situation is going to look much different if you work in a healthcare setting, in terms of patients that you're going to, knowingly be in contact with, or be notified that, patients that you've been in contact with have later tested positive. So some of the advice we've been giving people is to keep track of those notices and those exposures, keep a little file handy, prepare for the worst. You don't want to be scrambling to look for this information after you contract COVID and you're ill. You want to have this information handy. So if you see inter-office memos like that going out, save them, print them, put them in a little folder so you have them handy. Again, obviously, if you work in a healthcare setting, we're going to be talking about a much different, situation and much more difficult information to be able to keep track of. So if you have any specific questions or, a way we can work out how to make that work, certainly, we can tackle those together. Karen, do you have anything to add about that specific point?
I would add, there's a lot of people who, there may not be memos coming out, but if you're a truck driver and you go to pick up, your load and you talk or drop off a load and you talk with the people on the dock and they say, oh my gosh, 3 people are sick, maybe make a little note of that. Bob told me that they had 3 people out with COVID. Then you can remember, then you're not going, oh, I talked to someone there, write it down. Keep track of those types of things because it is really important to have that evidence. Even with the presumption, you still need to prove, or it's still very helpful to prove or add evidence to support that it was a work-related exposure.
Yeah, Karen's really correct because you're going to forget kind of what day you went to that dock, right? And,
Yes.
Was that 6 days ago or was that 14 days ago, right? So you're going to get, confused. You're not going to be feeling well and you're not going to want to be looking for those things later when we're trying to get you set up. So definitely keep those notes. The second piece of evidence that's going to be important is the medical evidence, medical diagnosis, records from your physician, records from your test site where you were tested, as well as a note from the doctor to support your need to be off work. So you're going to need a doctor's note to say, that you are to remain off work, how long you're going to remain off work, so we can make sure that you can get paid benefits for that time off, however long, your recovery takes. The last piece of evidence is proof of permanent disability, if any. We touched on this a little bit earlier, and that has to do with kind of those residual effects, right? So things that you're noticing, about yourself that are different now, whether it be shortness of breath when you perform activities that you used to perform, maybe you can't, run like you were able to, what residual effects, you're experiencing. The science is still unclear about this. Karen and I have talked to individuals with very different residual effects and unusual effects that everyone is still trying to figure out and is kind of different for everybody. So please make sure to make note of those things and follow up with your doctor and get those documented in the doctor's notes.
I would add, it's really important with respect to the medical diagnosis. You can't, it will not be sufficient under the law to say, oh, my coworker was sick and I didn't feel well, so I stayed home. You have to go to the doctor. You can't guess, you can't make that assumption. You have to get that medical diagnosis. You have to get the testing. And you have to have a doctor-signed work restriction. So please, make sure that you understand that and that anyone that you're talking to about this understands this also.
Okay. So that is it for the slides that we've prepared. I have our contact information up, our email addresses, our phone number is there. We have a website, ridgedowns.com. On our website, you can find a spot to sign up for our e-newsletter, where we try to keep you updated on any urgent changes or developments in the area of workers' compensation and personal injury. We also have a Facebook page at Ridge Downs. I invite you to like our Facebook page. We'll keep updates there when things happen, as well as post a lot of really cute dog pictures. We sponsor a guide dog. We currently have a puppy named Demi that is absolutely adorable. So if you like cute dogs, please check us out on Facebook as well. I'm going to go ahead and stop the screen share so that we can answer any questions.
And while Amy Lee is doing that, I will add that we are very pleased that you came and that you're interested in this topic. We are happy if questions come up later, please ask. We're more than happy to talk to you about any of these things. If your group would like us to have a virtual presentation for them, we're happy to do that. And we're going to be happy to provide copies of this presentation for you if you want to share it with anyone.
So everyone who registered,
sure there's questions.
Yes. Everyone who registered for the presentation will receive an email with a link to the copy of the video. So if you found this information useful, go ahead and share that with coworkers, friends, and family, anyone that you think would find it interesting.
Let's see. What other documentation besides doctor's notes is important? So why don't you go ahead and answer that?
Sure. So a lot of times your testing is not done at your doctor's office. You may go to a Quest lab or something like that. There's special testing sites that have been set up, especially for first responders. So your testing and your lab results might come from a different location, than your doctor's office. The other thing that would be important that we touched on especially is any of that inter-office documentation about exposures that have occurred in your workplace, other coworkers, or other people that you've come in contact throughout your work that have tested positive and have been symptomatic, as well as making sure that you have doctor's note, a work slip to keep you off of work for as long as you need to for your recovery. So you yourself can't just decide that you have symptoms and you want to stay home from work. You have to get a note from the doctor to clear you for that time off.
I would add too that it's really important to have documentation of your exposure, or as many exposures as you may have. Obviously that changes a little bit depending on your workplace, but anything that you can do to show that if you're an essential worker and you're not quite sure you meet that 15-person requirement, which I think can be interpreted pretty broadly. I don't think it necessarily means 15 people in your little area. I think it means 15 people in a broader workspace. But if there's some question about that, document that. If there's question about your exposure, document your exposure. All right. Oh, if your exposure was prior to testing being available, if you had recovered and were asymptomatic, what are your options? Just try to get the antibody test. I would say yes, that would be correct. If you were asymptomatic, you probably didn't miss much work and you probably don't have permanent disability resulting from your exposure. But if you did miss work and you couldn't get a test, yes, get the antibody test, because that would go back to support your inability to work, and possibly we could get you benefits for that.
And also, if you fall back to that early time in March when things just started, there was a time period under the rules where you needed just the doctor's diagnosis. So if testing wasn't available at that time, but you had visited the doctor and the doctor believed, firmly that this is what you were suffering from, that certainly helps as well.
All right, I have a question about what documentation would you need, like a FOIA request? And I would say, yes, that certainly could be helpful. I mean, every case is a little bit different, but yes, you could use the FOIA, you could FOIA documents for exposure information. I mean, that obviously only works if you work in the public sector. You can't FOIA a private employer. But if you work in the public sector, yes, that would be certainly appropriate and often something that we would use. We might be able to subpoena things from a private employer about exposures. Certainly you could subpoena the size of the employment population. Let's see, are there more questions?
All right. We have one more there, Karen.
We have one more
from Nicole. So Nicole asks us, she had an exposure at work and developed symptoms about a week later. The company health office told her to just stay home and set up testing. She did not follow up with the doctor. So if testing was not done, I'm a little unclear from the question. If the testing was done and you didn't see the doctor, if the testing was done, that's great. If it hasn't been, if no testing has been done, I definitely would suggest an antibody test. Like Karen said earlier, you know, you can try to confirm now with an antibody test. But I guess my other concern at that point would just be documentation of your need to be off work. If you didn't follow up with the doctor, to have the doctor keep you off work. It sounds like maybe a corporate health officer, in terms of, you know, if you have a company clinic there, if they kept you off and indicated, you know, you needed to stay home as well. Those are records that we can obtain.
And I would add that if they paid you while they told you to stay home, it's less of an issue than if they didn't pay you. If they didn't pay you, I would go get that antibody test in order that we can pursue getting you paid for that time frame. If you were paid and then have really no residual symptoms, you're probably fine.
Okay, I'm not seeing any other questions pop up at this time. So if that's it from everybody, I'm gonna go ahead and say goodbye and thank you for joining us today.
We very much appreciate your interest.
Thank you.
Bye-bye.